Anybody else honorables? No, you're still honorable. You're still honorable.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket is in re amendments to the Florida Rules of Judicial Administration, etc. Counsel, please proceed.
May it please the court, I'm George Tragos. I represent the Rules of Judicial Administration. I would also like to introduce Kevin Johnson from Civil Rules, the Honorable Donald Scaglione from Criminal Rules, Michael Upperman from Appellate Rules, Twyla Sketchley from Probate Rules, Ashley Myers from Family Rules, and to my right is Joel Silvershine from Juvenile Rules, and next to him, the Honorable Judge Eaton from the Criminal Court Steering Committee. The court requested this argument pursuant to a draft proposed of a rule change pursuant to the court's June 16, 2010 charge to various rules chairmen, where we were asked to propose a uniform rule for procedure of computation of time periods. And in that were time periods with reference to emergency situations, which really was generated from hurricane disasters, and ways of extending this time limit. The court issued a administrative order, and in that order, 2.205A, paren A, paren 2, paren B, paren 4, to extend time limits in emergency situations, and proposed an order for the chief judges. The committee viewed the draft contained in the June 16th letter as a suggestion from this court, and therefore went about its business to draft a rule to make the time limits uniform. And in fact, I know the rule drafting is broader than what was contained in the June 16, 2010 letter.
Could I ask you a question?
Yes, sir.
What was wrong with the rule that the court sent over?
We didn't think there was anything wrong with the rule, but we thought one of the court's concerns was that, you said in there that when you were reviewing the rules that you were concerned that there was not a uniform way of computing time, that you found different ways of computing time in different rules. We viewed the Rules of Judicial Administration, and the purpose for having the Rules of Judicial Administration is to make standardization, things that could be used by all rules. For instance, in mailing, you had 3 days in criminal, you had 5 days in the other rules.
No, and that's true, but see, for example, we realized there was a problem in our using the word tolling in our order, and that's why we gave you the language suspend rather than toll. Tolling is back in the proposed rule. It says if the court is closed either as a result of an order of a chief justice. The chief justice doesn't close the court, the chief judges close the court. These are things, they probably, maybe were not even realized, I guess, but that's why we sent it over with the language to explain how it works. It works where the chief judge closes the court, and then the chief justice authorizes that by the administrative order. Tolling was getting confusing, so we didn't use the word closing. Having inaccessibility of the clerk's office as something that affects this that's not the court's issue, because we don't control the clerk. So there's some things in the rule. We like the uniformity, but it's the language that we're, I think, now concerned about as far as the changing of the wording, not the uniformity issue, but the changing. So was there something that maybe somebody didn't appreciate, that tolling became a problem, or that the chief justice doesn't close the court, or that there's about 5 other things that are problematic Not, they're not substantive philosophical differences, they're just problems for the court in these situations.
Justice, I guess maybe I'm not understanding the court's question. But one of the, I guess, the issues that, again, as lawyers, when we're looking at this, isn't necessarily the closing of the court as much as you can't file a paper, you can't, the clerk's office is inaccessible for some reason.
But you see, but that issue, which is the clerk's office being inaccessible.
Yes.
There are situations where a clerk will just arbitrarily close the court on before a holiday. We've had that situation. We don't authorize that. They can't do that. Now, we don't want to encourage, so there is, what we were dealing with is wanting uniformity, but then also trying to make sure that the issue about what is the effect of the court's order suspending deadlines in emergency situations. Fortunately, we haven't had that. So now you've expanded it to something that really becomes problematic because it's something you may or may not have known, which is that sometimes a clerk will close their office, but we don't authorize that. Now, that may create a problem that day for a litigant, but we're not sure we want to authorize that process through a rule.
I understand what the concern is. And I guess and hopefully I understand it, you feel that this is probably overly broad and that we've included a non-judge judicial person into the mix that could make a decision that the rules shouldn't really be concerned about, that we should be concerned about judicial action. And that therefore only a judge or a chief judge or the chief justice's order should have an impact with regards to filing or not filing or extensions of time.
Well, why don't we just start with the one of these, which is why you have the language about the chief justice closing the court. I mean, that's a very simple one. The chief justice does not close the court. He or she simply enters an order that will extend the time once the court has actually been closed. And so I think that should be an easy fix.
And that could be an easy fix, yes.
I mean, in the best of all worlds, you and I could sit down with Deborah Meyer, who's our staff lawyer, and we could probably fix this. And so what I'm hearing you saying is that if the committee strayed from any of the language suggested by the court,
yes,
it was not because you thought that the court's, it may have just been because you were focusing on a picture that wasn't maybe different from everything we, that's what I,
yes, there would be no problem. I don't think the committee would have any problem making the changes that you're concerned about, yes.
So if we just say, okay, we send it back and say, please do this, 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 do it through an order, and you can see if there's any problem, for example, tolling. You don't have a problem with not using that, with not using that word.
No, we do not have a problem. It was, I think that the committee just went broader and started looking at a lawyer's perspective in an emergency situation, and that therefore we went broader than we should have gone, and we would have no problem making that correction. Actually, I do have a presentation, but I was hoping to, if anybody else has any questions, because we were at a loss as to what the concerns were of the court.
You mean having an oral argument?
Well, I wasn't going to make any more argument if there are no more questions.
Well, I think the other part
areas.
just is that what's the frustration is that we have the rules of judicial administration, and then we had hoped that each of the committees would follow suit. And I think we've got some committees, and I got to defer to you, that didn't submit their conforming amendments.
Right. There were, one was the small claims, I think, said they wanted to wait until they heard what the Supreme Court was going to do. Mr. Silvershine is here with reference to juvenile rules. Juvenile rules, in their method, one of the things we provided for was that a rules committee could, in their own rules, provide some exceptions if they had some different circumstances, which I certainly understand. What Juvenile Rules did is they put a sentence in there saying that Juvenile Rules will not follow this rule, as opposed to just making some exceptions.
There isn't a provision for court closing or periods under 7 days. Was that a intentional omission?
I think that the language was general enough to cover, I'm wrong, but to cover any time of court closing. I don't see that limitation in there. Yeah, yes. Sorry, yes, Justice.
I have a question, and forgive me if I overlooked something in the commentary that explains this, but I'm specifically focusing on subsection 4 of 2.514, subsection, I guess it's A.
Well, 4 is closure of the courthouse?
Closure of the courthouse. I'm having a conceptual problem with understanding how these extensions or how the computations of time apply to courthouses.
All right.
Explain.
All right. No. And that was actually raised when we first drafted or started drafting this rule. I'm from Pinellas County, 6th Circuit. We have 2 counties in our circuit, and we have, in Pinellas County, we have 3 courthouses. In Pasco County, we have 2 courthouses.
Well, and I can assume that anything that should be filed in Pinellas County can be filed in the clerk's office in any of the courthouses, or is that not correct?
No, actually, we have 5 courthouses, let me say. No, because some courthouses strictly have traffic, and they won't accept civil, full felony civil filings. Okay. Or if you have a circuit filing and traffic is county and the clerks are by county, sometimes they won't accept a circuit filing in a county like traffic division, which is strictly a county division. And therefore, you could have situations, and it has happened in Broward, I'm told, because someone was from Broward when we had a joint ad hoc committee of all the rules committees, that in Broward, you actually had one courthouse closed, one courthouse open, but the lawyers who were around the closed courthouse didn't know the open courthouse even existed at the other side of the county, that it was actually open and functioning. And it was, again, an emergency situation. We felt that it was important that we put a provision in there for when only certain courthouses within a circuit or within a county are closed, but the other ones are open. And we had a couple of members that were very strong on that issue because they felt that it could be a really severe problem.
Well, what if it's a statute of limitations issue? And it's got the lawsuit has to be filed by a certain date. There's a courthouse on one side of the county that's open that would accept civil filings, and there's a courthouse, the main courthouse maybe, is closed. What happens?
He would go to the open courthouse.
And if he doesn't go to the open courthouse, he's
Right.
He's toast.
Right.
Okay.
Until we have e-portal and e-filing, and then
Correct.
a lot of this
Then midnight on Saturday night, he could file it, right. And hopefully that'll happen sooner rather than later. But yes, he'd have to go to the open courthouse to do that filing.
I have to look back. I think that, at least we felt in our analysis, that the issue of it dealing with closures less than 7 days was needed to be addressed, and that would address some of the Juvenile Rules Committee's concerns. But we'll have to, we can't redraft it right here.
If that happened, it was not our intent. But I'm in reading this initially, I can't find where there's that limitation. Okay.
Again, okay, so if it's not there, you're fine to make sure we have that provision.
Absolutely, because I know that was not our intent to do so. I'll just make a closing comment then and move on. But as always, the Florida Bar is appreciative of the court trusting it with the responsibilities of court rules. Florida Bar takes its responsibility seriously and feels it is the best forum for such a discussion. The variety of lawyers involved in the discussion and the dedication of the lawyers and judges to the process serves the cause of justice and the needs of this court. I'm a past chairman of the Criminal Rules Committee and the Criminal Law Section. I know that this court at times has been frustrated with what it perceives to be a less than timely response to requests. I assure you that no one wants these requests to be timely more than the members of the Florida Bar. However, we feel it's our duty to provide this court with the best possible product to provide members of the Florida Bar who must live with these rules with an opportunity to invest in the promulgation of the rules. And therefore, what we may sometimes view as slow is in reality an enhancement for the long run in the practice of law and the efficient and cost-effective search for justice and truth. I appreciate the time, and I appreciate the interest, and I appreciate the input. I know that we have tried to, and this is off my thing, but there have been trying to be a more informal way in which justice can input into the rules committees. These kinds of suggestions, Judge Prunty, are just the logical way for you to just, if you tell us what your concerns are.
What can happen is that when the letter goes over,
right,
before a petition is filed, and there is any issue where someone doesn't understand the extent of the charge or the language used before you start drafting, there can be communication. Once the petition's filed, the court sees that as then the end of any communication. So our clerk, Tom Hall, is always available to answer questions, and if you have...
I know I called Tom about this, and I said, what's the question? Tom said, I don't know. So I did call Tom up about it and ask him, Mr. Hall.
If there's ever an issue on a referral, we would hate for the Rules Committee to go down a path, and I guess here, the frustration we had was seeing that we thought we had a simple solution, the rule that was sent over, and then, as you can see,
we expanded it, right. And like I said, those corrections, there is no one that I believe would have any concern with the concerns of the court and making those corrections and those changes. Okay? Thank you.
Morning. I'm Joel Silvershine. I'm here in my capacity as chair of the Juvenile Rules Committee. We're here mostly because of the expansion of what was originally sent down by the court. We have really no problem with the concept of uniform computation of time when it comes to those emergency situations when the courthouse is closed. Being an occupant of the Broward County Courthouse where a pipe will occasionally break, and we had the situation several years ago where a pipe broke in the clerk's office and flooded the clerk's office, and it became a real problem, and we had to apply for a tolling of time with the court, and then that was done. That is not an issue with us. And we have incorporated those changes within the individual rules dealing with delinquency, dealing with dependency, dealing with children and families that need a supervision in those particular portions. Where we have an issue is with the expansion or the elimination of situations where if the rules call for a response less than 7 days, that you eliminate the way the rules read now, that if you have a period of less than 7 days, you don't count intermediate weekends and holidays.
Well, I think what they're saying, and I don't know if this wasn't a communication, that should be in there. I mean, we're saying it should be in there. If it's in there, does that solve your major problem?
Yes, it does. I mean...
So isn't this, I mean, this is why we're all flying up here and we're having this conversation. It just seems that I don't know why that your concern, which is a legitimate concern, because you're talking about shelter, especially with juveniles who are both the shelter as well as the...
Detention hearings, right.
The detention hearings, time is critical.
Correct. And the way our discovery rules are written, things in juvenile move a lot faster.
They have to, because
they have to.
There's that 21-day maximum holding. And so
right, and the discovery rules are 5 days. And there's an issue with subpoenas on law enforcement officers. That's also 5 days. And there could be a conflict between the statute and the rule. And those are issues that we're concerned about. When we were asked to respond, or as an individual committee, all the committees were, we read this very carefully, and we saw this as a problem dealing with us. Number one, although uniformity is a good idea, the problems of juvenile, not necessarily the problems of civil or probate
But
or
still,
small claims, right?
time frames that are less than 7 days are, can be in family, I mean,
Correct.
it's across all the cases. We would just, you know, when I was working on this for changing the administrative order, and reading, like there's appellate rules had one way of dealing with something, and it was just, they weren't because of the nature of the proceeding, it was just that somebody had drafted it at a different time. It's sort of like what happens with the legislature. You know, they might draft a statute one way one year and the other year, not because they had a different problem. So we were trying to get uniformity where we could. Obviously, in speedy trial, we recognize that's a different consideration for in a criminal case, and that's why we adopted a special rule to deal with that. So you're telling if we put in what we had that we sent to the Rules of Judicial Administration, your concerns would be eliminated.
Correct. Thank you. If there are no other questions, I have nothing further. Thank the court's time.
Good morning. I'm O.H. Eaton, Jr. I'm here for the Criminal Court Steering Committee. I have a couple of minor comments about this rule proposal. First, I wish to say I had no part in drafting this. You can tell that a lot of lawyers did. If you'll look on page 3, the very beginning, paragraph A, where it says computing time.
Wait, you're now talking about the appendix?
Yeah.
All right, let's just get that. Page C3, okay.
It's
Proposed.
2.514A,
Okay.
computing time. I would like to suggest that you strike the last clause of that says that does not specify a method of computing time, because I think all of the statutory times are procedural, so it ought to include all of those. Alternatively, you might want to just get rid of that comma that's after statute, because I don't know whether that's a dangling participle or what it is, but it appears to apply to other things, and I think it just meant to apply to that statute. Secondly, on page 4, where you have definitions, I question the need for definitions of last day, next day, and legal holiday. I'm sorry, I understand what those mean. That's pretty plain language, and I just don't know that it's necessary. My other comment, and that's the last one, is that I liked the court's proposal better than I like this rule. But I understand that particularly in juvenile, there's problems that are different from anybody else, and so somehow it's going to have to be addressed. I'll volunteer if you decide you want to send it back and have another committee or something look at it. Well,
No, heavens, no. Can't we just, if we send it back, can't we get
no,
this
if you
turned
want to have
around
a
quickly?
conference with your staff attorney or something like that. There are no questions. That's it for me.
Moment.
Yes.
The comma after statute was deliberate. That was actually how lawyers drafted it. We discussed the comma because we did really mean any of the rules or statutes that if there was a specific time limit that for instance, the juvenile needed in their rules as an exception to this, that if they pass a specific rule for computing time for a specific act, that would be an exception to this. And we did deliberately put that in there.
But I guess grammatically, it would be which does not, and when you have a comma, I don't know, I won't be grammarian, so I'll ask my staff attorneys.
My daughter's an English teacher.
She said this was okay?
I didn't ask her that.
Oh.
I should have. But you know, that was actually argued in committee, and they voted to put the comma in there.
How long did that vote take?
That wasn't a very long vote, but our intent was that all of those should be included in the exception.
You said,
Along with committees is relative. That's a very relative term.
Right.
you gave a very compelling statement at the end of your first argument about the process, but the court's seeing more and more the need to have, like when it came to the issue of court records, and now when we get to e-filing, uniformity, and we do call on the Rules of Judicial Administration Committee a lot to be in charge. Then you do have the substantive committees, but it does seem like we end up, and it's not, if it's small claims or traffic or whatever, some committees that are somewhat recalcitrant, and what they don't understand, and I'll say it here, if we have to do this is a case. If we have to go now and have another petition and consider it again, it's more work for us, it's more work for the public. And so if we're going to have this current process where the bar is the quarterback for these rules committees, there's got to be some consideration of efficiency in doing this. And in all fairness, our staff maybe put that rule together in, a day. We sent it over because we know what happens when we don't send it over. And what we have come back is, again, it has problems. And so, again, my wish would have been, as soon as if you saw some things that you wanted to expand, to say, we'd like to put in something about the clerk's office, write us a letter back quickly or call somebody and just say, is there any reason you had this word versus that, so that we don't have a year go by and then now have to have, it's time consuming.
Now, and I understand, and I'm sensitive, when I was chairman of criminal rules, I really, really tried, and he never complained that year, at least about criminal rules, about our responses and the timeliness of the responses. Unfortunately, everybody all the time doesn't always act the same way.
Well, we can just take maybe
Right.
the next time is that the rules committee that don't respond will just get the standard rule, and that's the end of the story. And
Right.
if they, it's too bad.
And we would really like more informal contact with the court with reference to these rules.
Again,
That is absolutely.
It can happen before the petition is filed.
Yeah, and we will, I promise you, we'll take advantage of that. And I will communicate that to all the rules committees, the availability of the court prior to the filing of the rule for some informal contact that we can have some input from you. Okay? Thank you all very much.
We thank you. We thank all of you for your contribution.
I'm sorry, are we going to get an order? Is that, Judge, going to issue an order
Well, it's
telling
up
us?
to the whole court.
Okay, what a corrections, okay.
We now move to the second case on our docket today, Kitroer versus Hurt.
It's ridiculous.
Good morning. May it please the court. Bard Rockenbach on behalf of the petitioner, Mitchell Kitroer. As you know, this case arises out of a motor vehicle collision which occurred on U.S. Highway 27 south of Belglade. As part of the Third Amendment complaint, the plaintiff added causes of action against the individual air gas employees who were supervisors of the driver of the air gas truck that caused the collision.
Was the driver of the truck a Florida resident?
Yes.
So that, because I was thinking, and you put this analogy in, that under the theory of the defendants, that if he was from out of state but working for the company, he couldn't be sued individually for his tort in Florida.
Correct. We don't have that problem here because he was a Florida resident, but taking the rule as proposed by the respondent, the corporate shield doctrine would this decision in the Fourth DCA would materially change the way personal jurisdiction is viewed when we have these cases involving out-of-state residents coming to Florida for various activities. It could be, a convention or a sales call or anything they can point to their employer and say, well, I'm not here because I want to be. I'm here because I was forced to be because my employer told me to come here and be in Florida, so therefore I can't be sued in Florida. And that would be a material change. I don't know how many, I don't think there's statistics on this, how many lawsuits there are that arise out of this kind of situation, but there are a lot.
Well, the plain language of the jurisdiction statute, which I've read over the years a lot of times, says a person, whether or not a citizen or resident of the state, who commits a tortious act within this state. Mm-hmm. Now, there are issues that in Doe v. Thompson, the person was outside, right? There was no question. It's from another state. And there was maybe even a question for statutory interpretation about what committing a tortious act within the state. But you're alleging negligent training by
these citizens 5 employees, yes.
Within the state.
Within the state.
The tortious act was within the state. Right.
Yes. Our position here is that whether or not the corporate shield doctrine is still valid, that rule does not apply to this case because Section 48.193 clearly says that if you personally commit a tort in this state, then you are subject to jurisdiction. And so when the Fourth District took the Doe versus Thompson decision from this court and applied it, because Doe versus Thompson, it discussed the corporate shield doctrine, but as a way of explaining why the CEO in that case was not liable, couldn't be held for personal jurisdiction in Florida because he didn't commit a tort in Florida, but the opinion doesn't expressly state that it is based on the fact that the CEO was not present in the state and he did not commit a tort. And so the Fourth District took that as an indication that the fact that he was just a corporate employee, an officer, that was the reason that he was not held personally responsible in Florida, and that they had to go to Texas to sue him.
Well, a question about the allegations here. The allegations are that each of them were in Florida training and that they personally supervised or trained this employee, correct?
Yes.
Now, if they contest, they say, yes, we were in Florida, but we had nothing to do with the training of this employee. At what stage so ultimately they would be found not liable because they had nothing to do, they could be found not liable for a lot of reasons, that their training wasn't negligent, but that they were not involved with that training. At what stage of the proceeding is that determination made? Is that something that can be made at the beginning, or is that you've got to accept the allegations, and then if later on they're found not to have anything to do with it, they just are, summary judgments granted?
Under the analysis in the Venetian salami case, the concern that you raise can be dealt with and has to be dealt with in the pleading stage to decide whether there is personal jurisdiction.
Okay, I thought that was the case, but I also thought they had said something about contesting that they really were involved with the training or supervision.
Yes, they have never countered or disputed the fact that they were involved in the training and supervision in Florida.
Well, we have a procedure that's set up that if they want to contest that, they can come in and have a hearing, an evidentiary hearing on that.
Yes.
And then the trial judge has to make a decision at that point. I mean, that's the whole part of the whole concept of the Venetian salami case. And that's how that's handled.
Yes, to have it done at a very early point in the case to decide whether the court can do anything.
But here it was not contested.
No, it was never contested. The only issue raised was this corporate shield doctrine, and it was raised as just as a blanket kind of jurisdictional immunity that I'm here because I was employed to be here, and therefore you cannot sue me in Florida. You have to sue me where I live. And that is just not what the Florida statute says. And even if we applied the corporate shield doctrine, it wouldn't require that result anyway.
So they never alleged That you failed to state a cause of action against them.
No. No. I would like to reserve the rest of my time for rebuttal. Thank you.
May it please the court, Dinah Stein on behalf of the respondents. And the corporate shield doctrine recognizes the unfairness of bringing non-residents into the state to defend themselves.
Isn't that the legislative decision? I cannot understand. I mean, I can understand Doe v. Thompson because I can see that there's some situations where somebody, again, they're out of state and they're the president, vice president, and not going to start to bring in everybody in the corporation into Florida. But here it's not contested that your clients, the defendants, were in Florida, and the allegations of the negligence that formed the basis for the cause of action occurred in Florida.
That's correct, Your Honor.
And so tell me where then, if it were one step more, where the defendant who drove the truck was an out-of-state resident but was working for the corporation at the time that he drove the truck and killed or injured, allegations is his negligence caused the death, that under your version of the corporate shield doctrine, he'd not be able to be sued in Florida either?
Well, I don't necessarily agree with that. Obviously, it was not an issue in this case, but if you go outside, either in Florida or outside Florida, and I think this is important because this is a doctrine.
No, but you have to be able to. So you agree that if the person that drove the truck, who worked for a corporation, who was working solely within his corporate capacity, injured someone in Florida, that there is no question but they can be sued in Florida.
I believe that is the case. I
so
believe driving a truck.
So what is the difference with this is a negligent act that it occurred in Florida that they are saying caused the death of the victim?
Thank you, Your Honor, and that is the heart of it. Our position is that the corporate shield doctrine applies to so-called corporate torts, and if we look at and the counsel in these cases, we've cited to, as you can see, dozens of cases going back 50 years in Florida and all over the country dealing with this doctrine. Not one of those cases has ever applied the doctrine to an automobile accident, and I think the reason for that is that it has never been deemed to apply to your basic tort, where you cannot separate the physical portion of the tort from the jurisdiction. In other words, if Mr. Dickey is in Florida driving, he has duties to be a safe driver in Florida, period, and if he causes a crash due to negligence, Florida has personal jurisdiction over him. Well, now when you take a traditional corporate tort, and if you look at all these cases, they deal with misrepresentations, antitrust, contract. In this case, we have a derivative type of tort with negligent training. Doe was similar. The place of the tort.
You say derivative tort. It's not a vicarious liability tort. It's an actual recognized tort of negligent supervision and training. And it's not a vicarious liability.
But my point is that the place of the tort in this case, Florida, the negligent training tort, is completely incidental to the injuries.
Well, but that's your argument, maybe, that you're going to be able to be successful on proximate cause, legal cause. The issue of whether they're subject to jurisdiction for having come into Florida, there must be is there a training center in Florida?
I know that they came to...
Is there a training center here?
I don't know.
Okay. They came to Florida to train employees. What if on that same day when they were training him, one of them gave him a bottle of tequila and watched him drink it and then let him go out on the road? Would that be is that a derivative tort? Is that a...
I think that would be a different situation, because then that would be the actual tort of giving someone the alcohol.
So we're just making up now. See, that's the problem. Aren't we just making up something that is different from the statutory language, which says commits a tortious act within Florida?
Well, first of all, if we take and we're going by the strict language of Doe, and Doe considered personally of whether you're strictly in your place of employment.
Now, what about Your Honor, strict facts of Doe, though? I mean, don't we, when we look at Doe, I understand there's language in there that you can use to support your position, and that's what you're here to do, and I understand that. But don't we really, in determining what the holding of Doe is, don't we really have to consider the facts that were at issue there, and that if there may be some broad language in there that doesn't really fit those facts, and that's what this case is about. I mean, you've got broad language that you can use to support your position, but the facts there are clearly distinguishable from this case. So don't we have to look at the facts?
Well, we certainly have to look at the facts, and I'm not asking this court to ignore the facts of Doe. What we're doing is extending to the other cases, because this doctrine didn't evolve spontaneously in Doe. The Doe court recognized...
This doctrine does not, I've never seen, this, I must tell you, I looked at this, and I said, I can't believe this is the law, because it does make sense for someone, a man or woman, sitting in Texas, making decisions that may affect other states, but they never leave Texas. They stay in their office and they make those decisions, but as a result, somebody may be hurt somewhere. That's a far, far different situation, particularly here in Tallahassee. Now, in Miami, you may not see people coming into the state as often as you do here in Tallahassee. You got as many people from Georgia, living in Georgia, coming in every day, doing jobs for their employers, as you do people from Florida. And if this is the law, then thousands upon thousands upon thousands of people come into the state, cause harm while they're here, and then they have residential immunity. You can't sue me.
Well, this doctrine has been alive in the state for now several decades, and again, if you look to the cases, the doctrine has been applied quite consistently and without much controversy. Again, not to these car accident torts, which I disagree would apply to the doctrine.
I guess again, the doctrine, and just want to make sure, the doctrine you're talking about is the Doe v. Thompson case. But I think could you answer for us conceptually? Because if I were here looking at Doe and you say, listen, the guy was in Texas, never, again, on the phone, never left the state, there might even be an issue of minimum contacts. You might have it under the second, whether due process is satisfied. So we have protections that we just don't hail everybody from the whole world into Florida. But yet we're concerned with protecting our Florida citizens, and now with the internet we have a whole other thing. It seems light years different to take the facts of Doe and then this fact, which is, and you've called it again, you said a derivative tort, but it's actually a tortious act. That's the act that they committed. It was a tortious act within Florida, the negligent training. And so for us to wander, you could argue in the Doe case that's not a tortious act within Florida because it was done outside of Florida. But here, you can't do that. That's why I thought when I first read it, I said, oh, you mean they weren't in Florida? And they go, no, they were in Florida committing their acts. So I had that same problem that Justice Lewis had. I said, I'm not sure. Where did this morph into that situation?
Well, the reason is, and if we let's use this case as an example, these defendants are middle managers who have no control where Airgas Carbonics places its plants, and to do their job, they essentially have to come to Florida to train, to do what have you.
But that distinction, I don't see how that really gets you anywhere, because the truck driver,
yes,
who is sent on a mission down here to deliver something for a corporation that's somewhere else, also it's got no more choice about coming down here than those people did.
Well, the corporate shield doctrine doesn't protect from the entire scope of employment, and that's something Judge Posner pointed out in the Rice case that Judge Gross cited below, and I think that's an important distinction, is that he said this isn't a scope of employment issue, it's in furtherance of employment.
So what difference does that make?
Let me ask you this.
What
how
difference
do you
does that
parse
make?
out the different torts? That's what I don't understand. You can agree that someone who works for a corporation and they hit someone with a car, but that's fine, and that tort is fine. Where do you draw the line? I don't understand where, with your argument, what torts would be included and what torts would not be included.
Well, the position we took in the briefs is that the torts that you simply can't separate from your employment would be included, such as
But the tort, he's driving the truck for his employment.
Well, but driving it negligently doesn't further employment, and that's...
What's the difference of that in training negligently?
Because the training tort simply can't occur in the absence of the defendant's employment. If they weren't employed, you can't just...
Did they assess this guy and assess that he was not a good driver?
Well, we disagree with it factually, but for the purposes of jurisdiction, we're accepting their pleadings. But assuming that did happen, they were still, again, if it weren't for their employment, they would have never been in Florida assessing his driving because...
So if these same people came to Florida and they came here to negotiate with someone about a contract,
yes,
and they made misrepresentations in the negotiations for this contract, would they then be immune under your definition of a corporate...
Well, Your Honor, they would not be immune if these were intentional misrepresentations.
I'm not immune. I mean, would they be subject to jurisdiction?
If those were intentional misrepresentations made either in their personal interest or what have you, they would absolutely not be immune from jurisdiction. The corporate shield doctrine has never protected people in those instances.
I'm still struggling with where you are drawing the line. What torts are and what torts are not?
The torts that cannot occur absent employment. And for those torts, I use as an example this one. It could not have occurred absent the corporate employment of these defendants. You just can't go out on the streets and negligently train people.
I really don't see how that differs from
well,
if they're negotiating a contract. They would not be there negotiating that contract but for their employment.
Well, let me then, first of all, and again, I go back to the fact that this doctrine has worked very well for many decades and has never been opening the doors to these types of torts. But let me just make another point.
Have we had a situation? See, it's interesting you're saying that it worked very well. Have we had a situation where it was applied to a tort in Florida?
Yes.
And what case was that?
Yes. Well, in the Snibby case and the Trammell case, the courts both noted physical presence in Florida.
Smitty and Trammell?
Snibby, S-N-I-B-B-E.
So what were the facts of that?
In the Snibby case, that had to do with the plaintiffs were trying to get an injunction against some officers of a charity. And the court said simply because they were in their corporate employment during the tort.
Well, that's not a decision of this court.
No.
There are no decisions from this court.
No, the only decision from this court is Doe. Let me make another point on this, and I think it's important, and that is the arbitrariness of when we're drawing the line at physical presence. This tort could have just as well happened in Georgia by video.
Well, but the legislature drew that line. That's in the statute, isn't it?
Not according to the interpretation from Doe, in that Doe means by your own...
But I mean, the statute, I mean, one of the problems I have with this argument, and maybe ultimately with this doctrine, or at least some incarnations of it, is it just seems to be totally detached from the text of the long-arm statute. That it's just kind of, floating off out there, and you can't look at anything in the actual text of the statute that was adopted by the legislature and come up with these distinctions or the contours of this doctrine that you're talking about. It's all just kind of a creative enterprise, and that concerns me.
Well, again, and if you look, just staying within Florida, and there are many, many cases in Florida.
Well, there are things in Florida that concern me, don't get me wrong.
Yeah, it's been a very stable doctrine, and when I say that, I mean, this is really the first case I'm aware of where there's been this kind of fractured court, and we could say, well, this is because the facts are different here, but I disagree with that. I disagree.
I question your representation to the court that this is a very stable doctrine and has always been this way. If you look at the legislation, when I first started practicing, we didn't have the long-arm statute as it is today. And before, it was much more restrictive, but it sort of opened up some with some of the U.S. Supreme Court cases. And then this provision was placed in the law. And I'm not aware of this court ever, where the employee came into Florida, applying some kind of corporate shield doctrine. It has been reserved for those cases of somebody sitting in another state, they never come into the state, they don't act on their personal interests, and they make some kind of corporate decision in another state, but that may have some impact in Florida. Never, and you tell me if where's the case, if there's one from this court that you keep representing as having some kind of long history of stability.
Well, Your Honor, I don't mean to have represented that there's been a line of cases from this court. I think we've been pretty consistent that Doe is the case from this court.
Well,
I'm talking about the appellate courts.
Clearly, as the chief has asked you, is an out-of-state person making a decision in a corporate capacity, never coming into the state. Isn't that correct?
Yes.
Okay.
Yes, that's
Fair
correct.
enough. Okay.
And let me then address that, and why we're asking that the court extend it to these facts. Because Doe was the CEO of a large corporation. He was alleged to have made bad safety decisions from out of state, and he was insulated from jurisdiction, whereas here, and I think the problem with applying it to physical presence just as an absolute rule is it hurts the lower employees who really don't have a choice of when they come into the state.
See, here's my problem with what you're saying, and it really goes back to what I've seen as a distinction in what the statute says, which is commits a tortious act within the state. And there have been some cases that talk about whether you commit a tort in the state, but the actual words are commit a tortious act within the state. We've said it doesn't always require physical presence, but it depends on the particular facts. So when someone's physically present to commit the tortious act, we would be disregarding the plain language of the statute. And the other thing that I think we're forgetting here is that, as you said, you agreed that they can be sued. They're not even, they can be sued in their home state for something that they did for the corporation. The only benefit that they get, as does the plaintiff, is that the corporation, I'm sure, I doubt that they had to go out and hire their own counsel, that the corporation defends them, that they're an employee, and and ultimately the corporation will end up, being liable vicariously for acts done by its employees within the course and scope of the employment. That's why we've got vicarious liability of the corporation. So I think we're separating the idea that they shouldn't have to come to Florida to be sued when the upper level does, as if somehow they're going to be left on their own when they're in Florida. And so again, we got the plain language of the statute, and then we have the fact that if they act within the course and scope of their employment, the corporation is ultimately responsible vicariously for their actions.
I agree with that, and let me just clarify one more time. We're not saying that any act within the course and scope of employment is shielded. That's not our position. It's really for a narrow category of torts, and I want to make that clear, because if you go beyond the scope of your employment, Florida has always recognized an exception to that doctrine, and that I think allays Judge Farmer's fears in the dissent, because he did say that what you could do is end up protecting employees who do something that the corporation would disavow, and that is not our position at all, and never has been. If you do that, you come to Florida, period. All bets are off, and you don't get any protection. This is, again, for just a narrow category of cases. And let me just also say that the flip side of what Your Honor is saying is that there's no real, and I mean practical, unfairness to the plaintiff to apply this, because as Judge Gross said during the oral argument below, plaintiffs, you've got your deep pocket. I mean, you've got the corporation, and it's not that the plaintiff is losing something other than perhaps, again, a practical advantage, but they're not being disadvantaged by application of a doctrine.
Where's that in the statute that we have to look to add advantages or disadvantages? That's not in the statute, is it?
No, Your Honor. For statutory interpretation.
What is unclear about committing a tortious act in the state when the person is here and does something wrong?
The word personally, and this court has already interpreted that to mean that it can't be solely in your capacity as an employee.
And that was in the out-of-state context. No?
That is correct, although they did not distinguish on that basis. They distinguished on the basis of him.
Let me ask you this. These folks come into Florida, and they are there to supervise. And they watch the mechanic put one lug nut or two on a wheel of a tractor trailer. just watches, supervising, and they have the obligation to supervise. Didn't even train the people how to put it on. And they send the driver out and the truck wheel flies off and it hits a school bus full of kids. Oh, corporate shield doctrine, I was only there.
Well, first of all, I mean, I don't think there's any question that the corporation.
And that's corporation, the individual who stood there and watched that and supervised negligently by not doing his or her job and supervising the placement of that wheel on that tractor trailer.
Well, I would submit in Your Honor's example that if there is evidence of intentional or so far out of field of your corporate what you're supposed to be doing as an employee, that the corporate shield doctrine, even under the law we're advancing, wouldn't protect them. However, if it's a straight negligence case, I would submit that is the result that would be. I don't know that is a common. Again, we come up with a lot of hypotheticals, and I don't know how often that happens. And I would submit it doesn't, because this isn't a problem that's been addressed in any of these cases. But I would submit that is probably the outer limits.
Ms. Stein, you're now in overtime. I'll give you another 20 seconds or so to...
No, I appreciate your giving me the time, and I will allow my opposing counsel to do his rebuttal. Thank you.
Thank you. Just a couple of...
Can I just say, isn't the big difference, I'm reading back to Thompson. Thompson's affidavit states that he did not personally do anything in Florida. He did not personally do this. He didn't personally commit a tortious act. I mean, maybe there's some broader language in Thompson, but isn't that the significant distinction?
That is the significant distinction. That was Judge Farmer's point in the dissent and at oral argument.
I mean, the argument could be from Doe v. Thompson is that they didn't personally commit didn't commit a tortious act in the state. It could have been done on a statutory interpretation argument, not a rewriting the law out of thin air argument.
Yeah, the mentioning, the injection of the corporate shield doctrine into Doe versus Thompson was really unnecessary, because the court's opinion was based on the statute. The statute says you have to personally do something. This man did not personally do this act because he was in Texas and he made a broad policy, and then the people in Florida, they enacted the policy.
So we are very clear, in Doe, it was a sexual assault in Florida at a 7-Eleven store.
Yes.
And the issue, they were trying to get the president who made decisions about security, but nothing to do with that particular store.
Correct. Right. Just a couple of things I'd like to mention. Number one is that on the unfairness issue, the U.S. Supreme Court and the New Hampshire Supreme Court in Estabrook versus Wetmore, the U.S. Supreme Court in Calder versus Shirley Jones, both of those cases were where the courts rejected the idea that it was inequitable to force a corporate employee to come to the state where they did work and committed a tort, because the employee purposefully directed some activity, a tortious activity, to that venue and can be held accountable. Estabrook was cited by this court in Doe versus Thompson as sort of as one of the genesis points of the corporate shield doctrine. But in Estabrook, the court really rejected the application. Based on that, just said it was not inequitable to force this vice president. In that case, he had never even been to New Hampshire. They forced him to come to New Hampshire to defend the lawsuit anyway, because they said it wasn't really inequitable to force him to do that.
Isn't that really, though, again, trying to keep with jurisdiction? You
Yes.
look first if the act falls within the language of the long-arm statute.
Yes.
And no question this does. Then you look at an issue of whether due process would be offended. That's how I've, since law school, which was is becoming increasingly longer and longer ago, international shoe, that was the issue. The unfairness is addressed through minimum contacts.
Yes.
And nobody's contesting that these defendants had minimum contacts with Florida.
No one.
In fact, their contacts, the act was what they're saying that is the contact was directly responsible for the accident. And if it's shown that they didn't negligently train them, I don't get it. there's no,
Correct.
their judgment is for them. If they file an offer of judgment for whatever and you lose, you got to pay. So we got all other ways to make sure you don't do, or if your allegations are not true, there's frivolous lawsuits.
I just don't know if I could handle a case that had the corporate shield doctrine and a proposal for settlement in there, because you know there'd just be no end to it. Number
Stick
two,
around for the next one.
That's right. The second point I'd like to make is that the corporate shield doctrine is kind of a river without a riverhead at this point. The court that originally created it has rejected it. It was created by an intermediate appellate court in New York, and then a higher appellate court, and I always mix that up because it's not the Supreme Court, that's the lowest court, but the Court of Appeals appellate division, or whatever, they rejected it, but by that time, the federal system had taken the ball and run with it, and that's why Judge Posner said it was an impaired precedent, because there's really no source for this rule anymore, and people just keep applying it.
It reminds me of the economic loss rule.
That's right. There's another one, yes. And then the last thing is that I know that defendants would scream loud and long if we started making personal jurisdiction decisions based on a deep pocket. So we shouldn't have that interjected here. Thank you.
We thank you both for your arguments. The court will now stand in recess for 10 minutes.
All rise. Supreme Court of Florida is now in session. Please be seated.
We now come to the third and final case on today's docket, Southeast Floating Docks, Inc. versus Auto Owners Insurance Company.
May it please the court? I'm Jim McCrae, Law Office of Jim McCrae, on behalf of Southeast Floating Docks.
I'd like to serve as a preliminary question, ask you that if you're successful in our answering these questions in your favor, what attorney's fees would you be seeking?
Only the fees that were incurred after the offer was made.
All right, so this issue of this relation back thing, and I'd ask the other side the question that if there had been, in this case, a second trial, and the second trial had resulted in a $900,000 verdict, then you'd be getting those fees for that trial. So the significance, the fact that your judgment that was more favorable occurred because the 11th Circuit
reinstated the original jury verdict.
But the act occurred after the offer of, when you filed the offer of judgment, at that point, there was a zero verdict. I mean, there was zero because it was on a new trial and the judge had taken it away.
It was, when we filed the offer, the verdict had been reversed and a new trial order had been entered, setting a new trial some 8 months hence. Included with that new trial order was a complete case management order that they use in federal courts, which reestablished discovery deadlines, dispositive motion deadlines, amendment of the pleading it was a total restart. And there was nothing pending. There was no appeal pending, nor under the federal rules was there an appealable issue that
That's why I don't understand, why are we having to deal with this relation back question?
Because the district court said so. That was part of the district court's order denying our motion for fees.
So, but I'm struggling with how in the world, usually when you have an offer of judgment, that it's before it goes to trial, correct?
Yes.
So how in the world could these people have had an opportunity, your opponents have had an opportunity to evaluate that offer of judgment before the actual judgment that was finally entered, before you went to trial on that? I mean, because it was made somewhere down the line, how in the world did they have an opportunity to evaluate that before the actual verdict that is now the verdict was entered?
At the time the offer was made, there was no judgment. A judgment is only a judgment when it's final and all rehearings and all appeals have occurred, and then it becomes final. The fact that there was a judgment entered after the trial, it was set aside. It's gone. There's no longer a judgment.
But that judgment is now the judgment, correct?
No.
What's the judgment now?
The judgment now is the judgment that was entered after the appellate mandate.
But it's the same judgment that was entered before any of these appeals.
It was a judgment of no liability, but it's not the same judgment.
It may not be the same judgment, but in my mind, it is the same. Your client actually ended up winning back before any of this appellate proceedings took place.
We only
correct?
won after the appellate court reinstated the verdict. We actually lost. There was an intervening judgment where we lost.
I misstated what you had. The first trial you had, it was in your, this was a subrogation claim, and the first trial they found that if auto owners had acted in bad faith, and therefore you were able to...
No duty to indemnify.
At that point, then, the judge took that away, set another trial, but then subsequently entered a summary judgment for auto owners.
Prior to the new trial.
And then gave them a judgment of
$1.2 million.
And then after that, the 11th Circuit said, no, that was wrong, we're reinstating the first verdict, and then a judgment of no liability was entered after that.
Yes.
And at that time, that's why at 3, you had the 300,000 was probably, would have looked like a generous offer to auto owners because they had they had been faced with no, getting nothing, and you didn't know if you'd be liable or not.
It was, we weren't making a nominal
It wasn't
$10 offer.
And no one's making an argument this offer was made in bad faith or...
No, and the 11th Circuit expressly found, because there were many more grounds that auto owners raised in opposition to our fee motion. And one of them was that it was made in bad faith. And the 11th Circuit expressly found that it was not made in bad faith. And that's not one of the three questions that they certified to you.
The third question had me, I have some questions about the third question. That is whether this is the contract between...
Substantive law of Michigan versus substantive law of Florida.
And you agreed that the substantive law of Michigan would apply.
Yes.
And I'm assuming that Michigan law doesn't have an offer of judgment statute.
Does not,
Yes.
nor does it have a reciprocal statute for attorney's fees like we have in 57-105-7.
Does it have, did you provide in the contract for the prevailing party attorney's fees by
No,
contract?
the contract provides only for an award of fees to auto owners.
Now, in the conflict of law question, in terms of there's a procedural aspect to our statute, which is a rule of Florida procedure 1.442, which affects the timing. And then there's a substantive aspect, which is 768.79.
Yes.
For the conflict of law purposes, explain how the decision of the 11th Circuit previous decision that was overturned, the McMahon versus, not overturned.
McMahon versus Toto.
Yes. Why isn't that correct?
Well, it is. But there was McMahon 1 and McMahon 2.
Oh, I mean McMahon 1.
McMahon 1, the 11th Circuit considered this statute in a conflict of laws situation in McMahon 1. And in McMahon 1, they said this is a substantive provision. Therefore, if we are applying the substantive law of a foreign state, 768.79 does not apply. At that time, there were no Florida District Court or Supreme Court decisions on point. The day after, or within a very short time after McMahon 1 was issued, the 4th District in the BDO Seidman case considered the...
No, I understand that, but what I'm asking you is what's wrong with the reasoning of McMahon 1?
Of McMahon 1? It's the reasoning that's set forth by the 4th District, which has now been adopted by the 5th District. And the reasoning is the legislature has clearly stated the public policy that this statute is to be applied in any action in the courts of the state. It doesn't say any action in the courts of this state that's only applying Florida law. And the procedural, and that's what they said in BDO, you don't even engage in the choice of law analysis because of the clear legislative intent that it applies to all laws. And the policy distinction that I see is go back to, for example, 57-105. Has 57-105-1 sanctions frivolous suits or delay tactics. And the courts have held that applies even when the substantive law of another state applies because Florida is protecting the judicial machinery and the operation of the courts.
Which is pretty ironic that we would be, where parties agree to be bound by Michigan law that doesn't require, and substantive, attorney's fees is a substantive right generally, that the federal it's not the judicial resources of the federal courts are not our concern. So why in that situation isn't the stronger policy that Michigan law ought to apply? And I'm asking this more as I'm just not sure, and I realize there's a case that says no, it has to apply to all, 768 has to apply to all cases.
There's actually the Florida courts interpreting the statute have says all courts of this state doesn't just mean the Florida state courts, it means federal courts as well.
But how could the Florida legislature have a strong policy as to what is happening in litigation in the federal courts?
Because it impacts the citizens of the state of Florida and the judicial machinery within the state.
Well, you can say that, you can mouth that, but it really, how does it? I mean, the federal courts, if we had the resource of the federal courts, we might not need a 768 to begin with. I mean, it's apples and oranges as far as what happens in the federal courts, which are funded by the federal government, and what happens in the state court systems, which are perpetually...
The citizens of the state of Florida have to go to the federal court, and if the idea behind the policy is to shorten litigation and lighten the court load, thereby giving greater access and having people come through the system faster, whether you're in state court or federal court, it's the same. You don't want to be tied up in federal court because everybody there is turning down unreasonable offers. The policy is...
What is Rule 68, if you were bound by the federal rules, what is their comparable offer of judgment?
It only deals with costs. It's substantially similar. It mirrors, but it's only costs, it's not attorney's fees.
So isn't that reflects the policy that the federal courts don't think attorney's fees are required in order to, they have enough other things, they've got all those Rule 14 sanctions and
the federal courts apply 768-79. And as a matter of fact, after BDO Seidman was decided by the 4th District, they, sua sponte, they reversed McMahon Toto 1 and entered McMahon 2.
Well, they apply 768.79 because it's a substantive statute. I'm talking with a case that arises in Florida. I'm just talking about the choice of law. You were saying that the reason is there's a strong public policy reason for the statute, and I was just taking issue with that.
They've gone beyond that. The federal courts now have also, in the Minchis versus Ackerman-Sinterfit case, they said not only does 768-79/1.442 apply in federal court cases as well as state court cases because the legislature says so, but the Florida legislature can't discriminate against litigants in the federal court system. They basically,
well,
the
they
federal
say that
courts...
it's a matter of constitutional...
that the legislature could not limit the application of the statute only to the state courts and not have it apply in the federal courts that are within the state.
Well, it seems like 768 language, so it's almost like a chicken and egg type argument.
No, because 768.79 says, in any civil action for damages filed in the courts of this state.
But you
it doesn't say any...
You only look at 768 if you're applying for the law. Let's choice of law provision. What does the choice of law provision in the related contract say? What does the specific language state?
Specific language, it just says that the party shall apply the law of the state of Michigan. I can't.
You don't remember the rest?
No.
But my real question is it uncontested that the choice of law provision actually applies when you're using this type of situation of an offer of judgment rule?
No, I would say that it doesn't, because the legislature...
Is the scope of the choice of law provision more limited so that it's not applicable?
I didn't focus on the language to that degree.
I'm sure that if it did, with all the litigation, you would have pointed it out. I mean, I would hope.
I looked at it, okay, the contract says Michigan law applies, but the 4th and 5th District Courts of Appeal and the 11th Circuit have all said, even under that circumstance, this statute applies, even though the substantive law, they've discarded the talismanic nomenclature of statute of substantive versus procedural as dictating the result. They've gone beyond that.
When you filed the offer of judgment, did they file any kind of motion to strike saying that your contract trumps this offer of judgment?
They filed a motion to strike saying that it did not apply in federal courts and that it was preempted by Rule 68.
Okay, but not about...
But not about choice of law or any of the things that have been raised. And they filed it as soon as we served it. They filed it in the court. The district court never acted on it, because technically it's not, even that motion to strike shouldn't have been filed until later, but it disclosed the giving of the offer to the court prior to the second trial. But what rang loud and true to me from the previous argument was your statement, Justice Pariente, that you were being asked to rewrite a statute out of thin air. And that's really what Auto Owners is asking you to do here. In answering the first question regarding new trial, they're asking you to rewrite 1.442B1 to say that this statute doesn't apply in the circumstance when a new trial is ordered. In the second part, they're asking you to rewrite 76879(1), where the statute says that it applies in any case and the judgment. They're wanting you to tack on to the statute the judgment from a trial that was set when you made the offer. There's only one judgment that ultimately comes out of a case, and that judgment was one of no liability. We made it more than 90 days after the suit had been filed and more than 45 days before the retrial. There were no appeals pending. There's only one judgment. We only got that judgment after the appeal. And in the second question, which we haven't discussed, but the second question, they're asking you to rewrite 1.442(2)A and C, where it says an offer can be made by one or more parties to apply a benefits test. There's no benefits test in the statute.
There was something they said, though, that struck me, and I think there's an answer to it. They were saying that if we interpret the rule the way that this is not a joint offer, there could be collusion. That if, for example, you could have say if you had a irresponsible driver in a corporation, that the offer could be made by the irresponsible driver for $100,000 and with the requirement that you dismiss the corporation. But isn't there something that if you accept it and they don't pay it, I mean, there must be some way that if it's a sham offer, well, I guess then it's an offer made in bad faith.
If it's a sham, it's in bad faith. But in this circumstance, and this circumstance is not addressed by the recent amendment that adds where there are vicarious, technical, derivative liability, you can make an undifferentiated joint. Here the parties are jointly and severally liable. If Southeast Floating Docks owes $1, Simpson owes $1.
Do you think you get attorney's fees for litigating attorney's fees? In other words, ever since since you got your judgment, the whole issue that's been clogging the courts is the offer of judgment issue.
It's the entitlement. We're only dealing with entitlement. And yes, we would be seeking fees for arguing the entitlement fees, but not for subsequently
Counsel,
the amount of fees.
You're now down to about 2 minutes, so you're
Okay.
well into your rebuttal.
I will rest. Thank you, Judge.
If it may please the court, my name is Peter Gannett, and I represent Auto Owners Insurance Company in this case. The first issue that has been certified is we are asking this court to determine that a valid offer of judgment may be made before any trial setting, so long as there is a nexus between the dispositive judgment that is the basis for the fee award and the timeliness.
And where's the nexus is your language?
Yes.
All right. If, in this case, if the offer had been made like it was, and instead of this kind of quirky or somewhat unique procedural issue, there had been a second trial at which, again, Southeast prevailed, and then a judgment was entered. Any question that that offer would be a valid offer of judgment?
I think that based on reading all the cases and the rules, that would be a valid offer.
So it's
because there would be a nexus between the two.
Well, so only because, so you're really, because this doesn't happen in this particular situation, if they're asking us in this unique situation. I thought that the issue was just if you had you only had one chance to make an offer, and if you had a second trial, you couldn't make another offer. And why should they be worse off if if you calculated this wrong, in other words, at the time they made this offer, you thought you had already had a verdict of no liability that had been set aside. You're hoping to get $1 million, but they're offering you $300,000. How were you put in a situation where, oh my goodness, this is unfair for me to have to figure out whether to accept this $300,000 and stop this going? I'm just having difficulty seeing why the fact that the first trial had occurred but the verdict had been set aside puts us in any different situation than if they had gone to a second trial and won again.
It is different because when there's a new trial pending and there's an offer of judgment that has been presented to the parties, you're thinking about what is going to occur in the future.
Well, yeah, did you think about the possibility that what might occur in the future is that the 11th Circuit might have found that the trial judge had erred in setting aside the verdict to begin with? Isn't that something you advise your clients? We're not here, we don't have a clean shot here. They already had a verdict in their favor. That could happen again.
It could be, but first of all, the rule talks in terms of looking toward the next trial setting. So and it couldn't be a summary judgment, but the thought process, if you look at the rule, there's nothing about after an appeal, so the whole process is to take place before the trial, not after appeals and a second trial. And the reality is this: the lawyers of Florida have had some difficulty predicting what juries will do, understandably. It's even more difficult to have predicted the procedural posture of this case. Auto owners won summary judgment from the court. So at the time, it made the wise decision not to accept the offer. The trial court gave $1 million judgment to auto owners.
That was after the offer, and if you had made your, but the certified question says something which I think is actually it's incorrect. It says, may it be, if so, may offers, it first asked is, allow for offers of judgment in a separate second trial, and you've already, I think, said you would agree it does.
Correct.
Okay. And if so, may offers be deemed valid in instances where an appellate court reinstates the judgment of the first trial. Do you agree that there was no judgment after the first trial?
I agree that the measure of success occurred in the first trial and not after the 11th Circuit.
No, what I'm asking you is that there was no judgment. They didn't reinstate the judgment of the first trial. There was no judgment.
Well,
the judgment in this case occurred after the 11th Circuit reversed what the trial judge did.
But the measure of the award is based on what the jury did. Chronologically, it may have occurred afterwards.
You're mouthing the words, and I'm hearing them, but they just aren't penetrating to where it makes any sense in the interpretation of the statute. Are we interpreting it from what you're saying, the nexus issue, the statute or our rule?
I think it would be interpreting the rule.
Our own rule.
Your own rule, the rule of this court. And the question is, when do we have what I'd like to call the blackout periods, when you can't make these offers? You can't make an offer in the first 90 days, and you can't make an offer 45 days before trial.
But you're saying, but they made the offer at a valid time. But you're saying something occurred because they didn't have to go through a second trial, but yet won because the first trial verdict was reinstated. They don't get attorney's fees.
That's right. Because
and don't you think that the issue there, if they were trying to get attorney's fees, because I thought maybe they were trying to get attorney's fees for the first trial, and then I'd be but they're not. And the more you argue this, and if you lose, the more the attorney's fees are just mounting up here.
The attorney's fees are essentially just for the appeals process. And the courts of Florida have held that you cannot do it, you cannot use it for that purpose. Our problem is there was no nexus between the judgment that gave them the award and the potential right to fees and the timing of the offer. And that the whole purpose of the timing statute is to give parties an opportunity. One of the district court, that the judgment that was entered that would have been timely is a summary judgment for auto owners. That under one scenario, auto owners would have been entitled to fees had they made the offer. So there's got to be a nexus. You've got to connect the judgment, the ultimate judgment, to the timing of the offer. And if you don't do that, then parties can argue about whether it was timely or not. Let me give you another example.
Just one
Okay,
question
sure.
to clarify. We have the first trial is over, and we have order for a new trial, correct?
Correct.
And the parties are getting ready to go to trial on that. That's when the offer is made more than 45 days before that second trial.
Correct.
However, after the offer was made, the summary judgment against the offering party was entered.
Yes.
And then that went up on appeal.
Correct.
And it is that appeal that then said, no, we're going to go all the way back and reinstate the first judgment, correct?
Correct.
Okay. Where is the provision in the statute or rule that you contend that make that offer ineffective, void, whatever? What is the language in the rule or the statute to help me understand?
Sure. It's just an interpretation of the language of the rule when it says...
Which language?
Where it says you've got to be 45 days before the trial. The question is, what trial are we talking about? Could it be any trial?
Okay. All
So
right,
that,
your position is that the only thing that could have happened in any case that ever comes up and is ever reversed or changed or altered after appeal, the only one that can come or can be enforced is one that's made 45 days before the very first trial in the case.
no, that is not my position. My position is there's got to be a nexus between the ultimate judgment and the timing requirement. So it would have to be 45 days before the ultimate judgment. The ultimate judgment could be summary judgment.
Well, aren't you saying there's got to be 45 days before some trial that actually takes place?
Exactly. It actually takes place.
And here it was 45 days before a trial that was a possibility, but which never materialized.
That's exactly correct.
Well, how about a case that never makes it to trial and it's done by summary judgment? Is that void then?
Well, under the language of the rule, it talks about trial, but I think the reality is if you had it 45 days before the summary judgment was entered, that would suffice to advance the purpose of the rule.
Okay, then why wouldn't that interpretation apply in this case, 45 days before the summary judgment? It was entered less than 45 days, is that what you're saying?
No, the summary judgment was entered for my client.
Well, I understand, but again, I'm really trying to understand how we're going to apply this rule.
I think it's relatively simple if you just say that there's got to be a nexus between the timing requirement and the ultimate judgment that resolves the case.
But wasn't the ultimate judgment no liability?
Pardon?
Wasn't that no liability?
It was the verdict of the jury that found no liability that occurred before the offer.
Wasn't all of that wiped out when they granted a new trial? Well, basically all 11th Circuit did say, we agree with the first guy, no liability, and granted the summary judgment. Make more sense, rather than to say because there was a second trial set, you have to relate back to the first trial?
I think that you ought to use as the benchmark the judgment that gave the right to the
No,
to the
you
award.
used that as a benchmark to determine that you weren't going to accept the offer. However, that had been wiped out.
At the time the offer was made, I'm sure that auto owners was thinking about a future trial as well, and a possibility of summary judgment.
But when the offer is made 45 days before this second trial, and you say that the summary judgment, but for the first trial, would have been the trial, in effect, the trial, for purposes of applying the statute?
What I'm saying is, if auto owners had made an offer of judgment, it would have had to wait 45 days, had it done 45 days before summary judgment was entered, if that was going to be the triggering event as to give the award of fees.
So you could have filed an offer of judgment in that period, correct?
That's correct.
And if ultimately your summary judgment was upheld, you would have been able to recover fees from them even though there was no trial held.
Right, because the ultimate judgment would have been a summary judgment. That is correct.
But here, because again, and I realize that maybe this happens. This is like such a unique case. It's always amazing to me what the 11th Circuit decides they're going to certify, that they couldn't have, I mean, they're as equipped as we are to figure this out if they want to give you, fees or not, my view. So here, we're just really talking about some very narrow situation comes up, have you seen this situation before?
No, I think that the situation is going to be in a bifurcated trial
Well, in a
situation or a
bifurcated
second
trial, nobody, again, you've made an important concession. I don't mean that in a negative way. I appreciate your professionalism, which is that if the second trial had taken place, there wasn't any question, though, that you would be on the hook, and the same verdict, that you would be on the hook for the attorney's fees. I guess the way I see this being mitigated is that here you had a chance at that point in time when they offered the money to evaluate it in a way that wasn't unfair to you, which is, as I said, you could tell your clients, $300,000, it's a third of a loaf. It's, we got no loaf. We may get no loaf again, or we may get the whole loaf. And so, I think maybe $500,000 would be fair, but $300,000, we can end it all now. My attorney's fees are going to end up being another $100,000, so, you probably should cut your losses. Make that decision. Instead, they said, nope, zero, we're not, and they did it not on the basis that it was untimely, but they did it on the basis that Rule 68 should apply. Is that correct?
That was one of the reasons. I don't believe it was completely analyzed at that point.
And then from that point on until and continuing now, we've been arguing about one thing: who gets whether they get attorney's fees. And the more you argue, and the more you're entitled to do that, the more the attorney's fees keep on running up. And so, isn't that still promoting one of the purposes, which is to promote settlement of disputes? I mean, you're not caught unawares here.
Well, I think it is unfair, because at that point, the circumstance was changed. The auto owners wasn't thinking about the possibility that it could go up on appeal, it could be reversed.
How would they not? This is auto owners. This isn't like Joe Smith. This is auto owners insurance.
But the most immediate thing that was on the horizon was a possibility of summary judgment in our favor, which occurred.
The whole loaf. That's what I said. You could get the whole loaf, no loaf, or a third of the loaf.
Right.
That's what happens. That's why settlements occur, because you tell your client, we might be in a worse position or a better position. This is either a fair settlement, or let's make our own offer for $500,000 and let's see what happens.
And as you say, that maybe factually this is a little convoluted, but what I'm looking for is a rule that is clear so the parties know that there are certain blackout periods. Yes, you can make it before a second trial, but you've got to avoid these blackout periods. And the easy way to apply the rule is to have a connection between the judgment and the timing.
So is your ultimate argument here is, when should well, let me ask you a different way. When should an offer of judgment have been made in this case under your scenario? As I would understand your argument, it would have to have been made before the first jury trial. Is that what you're ultimately saying?
They could have made it any time more than 90 days after there had been service, or any time before 45 days before the first jury trial. And once that window of opportunity was missed, they couldn't make an offer of judgment for the first trial. Had there been a second trial, there's no reason why they couldn't have made it at that time as well. I'm just trying to get some clarity in the rules so lawyers of this state know there are certain blackout periods and you just can't make your offers.
If we try to rewrite that rule and put a nexus requirement in, do you know what would happen to the litigation on this rule that is already ridiculous? I mean, I can appreciate what you're saying is that this is unique, and we could answer the certified question saying, this unique situation, no, you don't get it. But to try to rewrite the rule to put a nexus requirement in, oh my goodness. So, you're almost out of time. Do you want to, on the third issue, talk about the conflicts of law, or are you conceding that it applies.
No, I will talk about the conflict of laws a little bit. That issue, based on the BDO case, basically lawyers have given up trying to argue about the conflict of laws. And I just think that in a commercial setting, things are a little bit different. If parties have a contract before they file suit that selects a particular jurisdiction as the law that is to be applicable, that this court should be able to look at that and see if the conflict of laws is going to make a change and would change the result. Up to this point, even the federal courts, as was pointed out, where there's no real strong Florida state policy, have just said, well, I guess that's the end of the story. We're not going to even apply the conflict of laws analysis. The cases involving the reciprocity statute in Florida have held that when there is a contract that selects the law of a different state, the Florida reciprocity statute on attorney's fees does not apply. And that makes a lot of sense. All I'm suggesting is that because there's certainly the law in this state shows that the right to attorney's fees is a substantive right, and the rule implying it is the procedural aspect. Since it is substantive, new right, where it changes the American rule, the court should be allowed to do an analysis on the choice of law. It doesn't mean that we're never going to apply the statute, or we are going to apply the statute, but certainly when you have two parties of equal bargaining power in a commercial setting, they should be able to select the law of a different jurisdiction. And if they so choose, just like they can get out of the usury laws of Florida, you can get out of the statute of limitations of Florida based on the authorities of this court, you should be able to write a contract so that the offer of judgment statute would not apply.
Well, did you write that in the contract?
It didn't specifically say the offer of judgment statute of Florida wouldn't apply, but
what did it say?
It talked about who had the right to attorney's fees. And in the contract, auto owners was the unilateral party to have a right to attorney's fees. And under the law of this state, if...
Auto owners, but not the insured?
Right. Or the indemnitor. It's not exactly insurance.
They basically covered the Southeast. So.
And under the law of this state, if this had not been a commercial setting...
So that's equal, they're equal to bargaining powers, unilateral attorney's fees to one, and that's equal.
Right. The reciprocity statute, you could opt out of it by simply selecting the law of a different jurisdiction. The cases in Florida have held that. And the question is whether or not that should be expanded or clarified to involve the offer of judgment statute.
You said something else about the joint offer issue, and you said there could be collusion. But
yes.
If an uninsured or a financial irresponsible party makes the offer and doesn't have the money to back it up, that's going to be rejected as being in bad faith, isn't it?
It could be, but let me show you a different area where there could be collusion.
How could it not be? If somebody says, I'm going to pay you $100,000, and they go, oh, just kidding, I didn't have that money.
Right.
That's good faith?
That very well may be the situation, unless it was a proposal that paid out over time and then the parties are back in court. But let me talk with you about another two problems. The one is collusion, where if you can simply write what would ordinarily be a joint proposal by saying, this tag-along defendant, we want them dismissed too, without specifying the amount being offered for each, the parties can just make an end run around this rule every time. You have a couple of defendants say, well, we'll give you our money, you just make the offer on your behalf. And the reason why we wrote the rule, or why this court adopted rules like in Lamb that said you've got to specify the amount being offered for each, is how are you going to determine later down the road who was the prevailing party? That was a big issue in Lamb, because you could have a situation where, for example, if you have a party that offers $3,000 to settle, but it's just on behalf of one defendant, but this tag-along defendant needs to be dismissed too. So if the judgment comes back for $2,000 from each defendant, or a total of $4,000 total of $4,000 from both defendants, does that mean that the offering defendant prevailed because they did better than the $3,000, or does it mean that the plaintiff made the correct decision not to accept it because the total was $4,000?
This whole rule, frankly, and has not done what at least the court ever thought, which is to promote settlement. And every time I hear about, or we have one of these cases, I just think for 18 years, it's been a frustration, because all we've tried to do is make it simple to apply, and we don't ever seem to be able to get there.
And I understand that, Judge, and I've read a number of your opinions that say as much.
If you could wind up here in about 30 seconds.
All right, absolutely.
We're in overtime.
Basically, we're asking the court, we put in our brief how we're asking that these questions be answered, is hoping that these rules would be clarified by answering in this fashion, and if any of these rules are answered, any of these questions are answered in a way that is the way we had asked, then we should prevail in this case. Thank you for your time.
If you want to add insurmountable and additional confusion to this rule, just judicially write in a nexus test. Try and express it. Or a benefits test. Because what you'll be saying is every offer of judgment where there's multiple parties, even if it's strictly one party making one offer, somebody's going to come in and say, well, it benefited him. It benefited him. It's really a joint offer. It's not a single party offer. And the choice of law, even if Florida law applied, and we had no right to attorney's fees under the American law, if we serve an offer of judgment, that would entitle us to our fees.
But if you say that the statute is a substantive provision.
Yes.
And the contract says that the law of Michigan shall apply.
Yes.
Why would you not look to the law of Michigan, not the law of Florida?
The analysis by the majority and the concurring opinion in BDO goes into it. The majority opinion says you don't even do it.
I've read
but
those.
Also the Weatherby case, the analysis, I go back to the Weatherby case. 57105 creates a right to fees. It's substantive. However, it still applies to cases where the foreign law applies, substantive foreign law applies, because it deals with the operation of the judicial machinery within the state. And the legislature has, and that's another policy where the legislature says don't file frivolous suits or you're going to be sanctioned, even if the law of another state applies.
And you don't think that a statute that deals with frivolous lawsuits is, you think that's absolutely analogous to the offer of judgment statute, which wants parties to try to promote settlement within or each other?
57105 is trying to promote settlement so that you don't start making frivolous claims.
Trying to prevent any, this is, no question this was a valid claim. Each of you had a valid point of view. I mean, they won, you won, it's,
right. And
you were a very good advocate to
but
get
both of
no
those
bad
cases,
faith.
both of those
Or bad
cases
faith.
discuss each other. They are related. That's why there's a little cross-pollination in the opinions where they refer to each other. And we're not just seeking fees for appeal. After the new trial was ordered, there was substantial activity in the trial case. It was a resetting of the clock. There was additional discovery. There were interrogatories. There were several requests for production. There were several intervening motions. There was the motion for summary judgment. There was the rehearings. We had about 8 full months of additional litigation in the district court before the summary judgment was entered. We're not just seeking our fees on appeal. We're seeking the fees after the offer was made, all of which would have been avoided had they accepted the offer or come back with one that we would have accepted. Thank you.
We thank you both. That's the last case on today's docket. The court is now adjourned.
All rise.